Question number 501. Confession is recorded, option A, by the judicial magistrate having jurisdiction only, option B, by any judicial magistrate with or without jurisdiction, option C, by any police officer having power of a magistrate under the law in force, and option D, by a magistrate empowered by the High Court for the purpose. Here correct answer is option B. Confession is recorded by any judicial magistrate with or without jurisdiction. Question number 502. A confessional statement under section 164 of CrPC can be recorded. Option A, during the course of investigation or at any time afterwards before the commencement of the inquiry or trial. Option B, during the course of investigation only and not afterwards. Option C, during investigation as well as during inquiry but before the commencement of trial, and option D, none of the above. Here correct answer is option A, during the course of investigation or at the time of afterwards before the commencement of inquiry or trial. Question number 503. A confessional statement recorded in accordance with the special procedure under section 164 of CrPC is can be used as a substantive evidence without being formally proved, cannot be used as a substantive evidence at all, cannot be used as a substantive evidence without being formally proved, and option D, either B or C. Here correct answer is option A, that is can be used as a substantive evidence without being formally proved. Question number 504. Which of the following is not an essential procedural requirement under section 164 of CrPC, namely option A, warning to the accused, option B, confession to be made voluntarily, option C, recording of statement in presence of advocate of the accused, and option D, memorandum at the foot of confession. Here correct answer is option C, that is recording of statement in the presence of advocate of the accused is not an essential procedure requirement of section 164 of CrPC. Question number 505. What is true about recording of a confession by a magistrate? Option A, a police officer should be present so that the accused may not flee. Option B, the magistrate should warn this is not necessary for the accused to confess. Option C, prior to the confession he should be left in police custody for some time, and option D, all of the above. Here correct answer is option B, the magistrate should warn that it is not necessary for the accused to confess. Question number 506. A voluntarily confession is admissible in evidence when made to option A, to a police officer, option B, to a magistrate having competent jurisdiction, option C, to a village sarpanch with a request to save him from police, and option D, where it leads to no discovery of facts and made to the police officer. Here correct answer is option B, that is to a magistrate having competent jurisdiction. Question number 507. If magistrates administers oath before recording the confession of an accused, the confessional statement is option B, good in law and admissible evidence, option B, bad in law and inadmissible in evidence, option C, good in law but admissible only on corroboration, option D, bad in law but become admissible on the corroboration by other evidence. Here correct answer is option B, that is bad in law and inadmissible in evidence. Question number 508. When the confession of the accused person is not recorded in the manner provided in section 164 of CrPC, oral evidence of the magistrate is not admissible to prove that the confession so made was held in option A, State of UP versus Singhara Singh. A is the right answer. Question number 509. While recording the statement of a child under section 164 of CrPC with regard to an offence under Protection of Children from Sexual Offences Act 2012, option A, the presence of the advocate of the accused is mandatory, the presence of the IO investigating officer is mandatory, the presence of the parent of child or such other person in whom the child has trust is mandatory, and option D, all of the above. Here correct answer is option C, that is the presence of the parent of the child or such other person in whom the child has trust is mandatory. Question number 510. A non-confessional statement recorded under section 164 of CrPC is a substantive piece of evidence, is not a substantive piece of evidence, may or may not be substantive evidence depending on the facts and circumstances, none of the above. Here correct answer is option B, is not a substantive piece of evidence. Question number 511. Statement of a witness recorded under section 164 of CrPC can be used for contradiction only, for corroboration only, both for corroboration and contradiction, neither for the corroboration nor for the contradiction. Correct answer is option C, that is both for corroboration and contradiction. Question number 512. Statement of a person recorded by a magistrate under section 164 5A clause A of the CrPC can be taken as a statement in lieu of examination of chief where the person is a victim in a case. Option A, punishable for the offence of kidnapping and the victim is mentally disabled. Option B, punishable for the offence of grievous hurt and the victim is physically disabled. And option C, punishable for the offence of stalking and the victim is temporarily physically disabled. Option D, punishable for the offence of voyeurism. Here correct answer is option C, that is punishable for the offence of stalking and the victim is temporarily physically disabled. Question number 513. Statements of any person may be recorded even at the stage of investigation by administering oath of such person by the magistrate. Under which provision of the CrPC it has been provided? Here correct answer is option B, that is section 164 clause 5 of CrPC. Question number 514. What is the distinction between section 161 and section 164 of CrPC? Option A, both are one and the same. Option B, Section 161 CrPC statement is recorded by the magistrate, whereas Section 164 CrPC statement is recorded by the police. Option C. Section 161 CrPC statement is recorded by the police, and whereas Section 164 CrPC statement is recorded by the magistrate. Option D. Section 161 CrPC statement is recorded on oath, and whereas no oath administered in recording under Section 164 of CrPC. Here correct answer is option C. That is Section 161 CrPC statement is recorded by the police, whereas Section 164 CrPC statement is recorded by the magistrate. Question number 515. Dash of CrPC deals with medical examination of the victim of rape. Here correct answer is option B. That is Section 164A of CrPC deals with the medical examination of the victim of rape. Question number 516. The section dealing with the medical examination of the victim of rape is inserted by the Code of Criminal Procedure Amendment Act 2005 is option A. Section 164A, option B. Section 166A, option C. Section 166B, and option D. Section 53A. Here correct answer is option A. That is Section 164A. Question number 517. Under Section 164A, the CrPC, the victim of rape shall be sent to the registered medical practitioner within dash from the time of receiving the information relating to the commission of such offence. Here correct answer is option C. That is 24 hours. Within 24 hours from the time receiving the information relating to the commission of such offence. Question number 518. Section 164A of CrPC makes it mandatory to examine the person of victim of rape. B is the right answer. Question number 519. During investigation of an offence of committing rape, medical examination of alleged victim may be done by option A. Only on the order of the magistrate. B. Necessarily on the request of the concerned investigation officer if he deems it fit. C. After the investigation officer maintains permission of his superintendent of police. Option D. With the consent of such woman victim or of any person competent to give such consent on her behalf. Here correct answer is option D. That is with the consent of such woman victim or any person competent to give such consent on her behalf. Question number 520. During investigation, a search can be conducted without warrant by option A. Any police officer, option B. The investigating officer, option C. Both A and B, and option D. Either A or B. Here correct answer is option C. That is both A and B. Any police officer and the investigating officer. Question number 521. When a search is required to be conducted outside India, a criminal court under Section 166A of the CrPC issue a search warrant, letter of requisition, letter of request, written order. Here correct answer is option C. That is letter of request. Question number 522. Where the relevant procedure in the CrPC has been provided in case when the investigation cannot be completed within 24 hours. Option A. Section 57, Section 157, Section 167, and all of these. Here correct answer is option C. That is Section 167. Question number 523. The investigating officer shall within 24 hours of arrest of a person transmit to the nearest judicial magistrate a copy of the entries in the diary relating to the case along with the accused. If the investigation is option A. Completed within 24 hours, not completed within 24 hours, not required, changed by the competent authority to another investigating officer. Here correct answer is option B. That is not completed within 24 hours. Question number 524. Under CrPC, to what maximum period an accused can be ordered to be kept in police custody by the magistrate? Here correct answer is option B. That is 15 days. Question number 525. For the authorization of detention of the accused in custody, the accused must be produced before the magistrate. Option A. In the person. Option B. Through an advocate, and option C. By producing an application signed by him. Option D. Through medium of electronic video linkage. Here correct answer is option D. Option A. In person. Question number 526. In Section 167, magistrate can order detention in option A. Police custody, judicial custody, jail, any custody as he thinks fit. Here correct answer is option D. That is any custody as he thinks fit. Under Section 167, the magistrate can order detention in any custody as he thinks fit. Question number 527. When the trial relates to an offence under Section 376 of IPC, the trial shall as far as possible be completed within a period of, correct answer is 2 months. Question number 528. Under Section 167 of CrPC, the nature of custody can be altered from judicial custody to police custody and vice versa. This alteration can be done option A. During the period of first 7 days, during the period of first 15 days, during the period of first 14 days, and during the period of first 10 days. Here correct answer is option B. That is during the period of first 15 days. Question number 529. What is the maximum period an executive magistrate may authorize the detention of an accused in custody? Here correct answer is option C. That is not exceeding 7 days. Question number 530. Can a police remand is possible for a person already sent to the judicial custody? Option A. Yes. Option B. No. Option C. Yes if necessary for the investigation in some other case, and option D. None of the above. Here correct answer is option A. That is yes. Question number 531. Default bail is given in the case of option A. Where the investigation is not completed within the time prescribed. Option B. Where the offence is bailable offence. Option C. Where the person applies for anticipatory bail, and option D. Where no reasonable ground exists for believing the accused guilty after conclusion of trial but before judgment. Here correct answer is option A, where the investigation is not completed within the time prescribed period. Question number 532. The accused has indefeasible right of bail when investigation is not completed. Option A, within 15 days, within 30 days, 21 days, 90 or 60 days. Here correct answer is option D, that is 90 or 60 days. Question number 533. On the non-completion of investigation, that is failure of the prosecution to file charge sheet within the prescribed period of 90 or 60 days as given in section 167 of CrPC, the accused person is to be discharged unconditionally. Accused person shall be released on bail if he is prepared to and does furnish bail. Option C, right of the accused person to be released on bail could be defeated by the subsequent filing of the charge sheet under any circumstances, and none of these. Here correct answer is option B, that is accused person shall be released on bail if he is prepared to and does furnish the bail. Question number 534. Bail granted under section 167 clause 2 of the CrPC has same incidence as bail granted under chapter 33 of the code. Option B, bail granted under section 167 clause 2 of the CrPC cannot be cancelled under section 437 clause 5 of the code. Here statement A is correct, statement B is correct, both the statements are correct and both the statements are incorrect. Here correct answer is option A, statement A is correct. Question number 535. For the purpose of section 167 clause 2 of CrPC, the period of 60 or 90 days will be reckoned from the dates of arrest, production before magistrate, after police remand, filing of charge sheet. Here correct answer is option B, that is production before magistrate. Question number 536. Under section 167 of CrPC, the magistrate authorized detention for a period of 90 days during investigation in cases of offences punishable. Here correct answer is option D, all of the above. With the death, with imprisonment for life, with imprisonment for a term not less than 10 years. Question number 537. What is the maximum period detention during the investigation for the offence of murder, after which of non-filing of charge sheet of the accused is entitled to be released on bail? Option A, 60 days, option B, 120 days, option C, 90 days, and option D, 180 days. Here correct answer is option C, that is 90 days. Question number 538. Under section 167 of CrPC, for offences other than those punishable with death, imprisonment for life, or imprisonment for a period not less than 10 years, the detention during the investigation can be authorized for a total period of 30 days, 45 days, 60 days, 75 days. Correct answer is option C, that is 60 days. Question number 539. When investigation is not completed within the prescribed period of 90 days and accused is in custody on expiry of the said period, if he is prepared to and does furnishes a bail, the accused is entitled to be option A, discharged, option B, acquitted, option C, released on the bail by the investigating officer, option D, released on bail by the concerned magistrate. Here correct answer is option D, that is released on bail by the concerned magistrate. Question number 540. For the purpose of section 167 of CrPC, the most essential requirement is that the arrested person should not necessarily be produced physically for the first time, should be produced first time through the medium of electronic video linkage, should be produced in person for the first time. Option D, should be produced in person for the first time and subsequently through the medium of electronic video linkage according to the direction of magistrate. Here correct answer is option D, that is should be produced in person for the first time and subsequently through the medium of electronic video linkage according to the direction of magistrate. Question number 541. Which section of CrPC deals with case diary? Correct answer is option C, that is section 172 of CrPC. Question number 542. Maintenance of a case diary by an investigating officer is directory, mandatory, discretionary, neither A or B. Here correct answer is option B, that is mandatory. Question number 543. Section 172 of CrPC requires that a statement of a witness recorded during the course of investigation under section 161 shall be inserted in case diary. A is the correct answer. Question number 544. On the completion of investigation, the officer in charge of a police station shall forward the police report under section 173 clause 2 of CrPC to Sessions Court, Chief Judicial Magistrate, any judicial magistrate, magistrate empowered to take the cognizance of the offence. Here correct answer is option D, that is magistrate empowered to take the cognizance of the offence. Question number 545. A charge sheet filed under section 173 of CrPC is an example of option A, public document, option B, private document, option C, patent document, option D, latent document. Correct answer is option A, that is public document. Question number 546. Every investigation is required to be completed without unnecessary delay under section 173. Choose the most appropriate statement. Here correct answer is option C. The magistrate frame charges after the filing of police report. Option C is the right answer. Question number 547. After completion of investigation, the police is to submit a final report to the magistrate. The magistrate, option A, is bound by the conclusions drawn by the police and accept the same if possible, recommended that there is no sufficient ground for proceeding further. Option B, is not bound by the conclusions drawn by the police and may order further investigation. Option C, may issue a process against the accused, and option D, both B and C. Here correct answer is option D, that is both B and C. That is Magistrate is not bound by the conclusion drawn by the police and may order further investigation, may issue a process against the accused person. Question number 548. Magistrate, after accepting a negative final report submitted by the police, cannot take action on the basis of the protest petition filed by the complainant and first informant. The statement is option A true, option B false, option C partially correct, and option D none of the above. Here correct answer is option B, that is false. Question number 549. Which one of the following provisions of the CrPC provides that the investigation in relation to the rape of a child may be completed within 2 months from the date on which the information was recorded by the officer in charge of the police station? Option A, section 173 clause 1, option B, section 173 clause 1A, option C, section 173 clause 2, and option D, section 173 clause 3. Here correct answer is option B, that is section 173 clause 1A. Question number 550. The investigation in relation to an offence under section 376DA of IPC shall be completed from the date on which the information was recorded by the officer in charge of the police station. Option A, within 6 months, within 3 months, within 2 months, without unnecessary delay. Here correct answer is option C, that is within 2 months.